It looks like we are here on a de novo appeal. It is brought by your client, Ms. Bowman, is that correct?
Yes, Your Honor. There's actually cross de novo appeals.
Okay, let me make sure I have the other one up. And Attorney Wasaki, who will be lead counsel on this?
Your Honor, I'm lead counsel for Mr. Tharp.
Okay, got it. All right, and
Your Honor, I don't know that it's consequential at all. There are two de novos. As far as we know, ours is the only one set, but I think at the end of the day, it doesn't matter. I believe the de novo filed by mom is moot based on subsequent rulings that were not de novoed.
okay.
So I think it's 6-1, half a dozen from with regard to their de novo.
Okay, I saw the first filing of the de novo, and then I did see some hearings occur in between there, and then a second filing of the de novo. So thank you for clearing that up. Everyone, you all have 20 minutes per side. Is everyone ready to proceed?
Yes, Your Honor.
Okay, let me get your timer going. Okay, that's one. Okay. All those in, well, let's go on the record first. Okay, we're on the record in cause number DF1610944. Counsels, would you please announce for the record?
Your
Yes,
Honor,
Your
Michael,
Oh, sorry. Go ahead, Michael.
go ahead.
I was just going to say Lacey Bowman here on behalf of petitioner Candace Collins.
Your Honor, Michael Wasaki and Jennifer Satajay here for the father, Mark Tharp.
Okay,
And Your Honor, my name is Carolyn Hill, and I am the amicus attorney for the children.
thank you. Thank you all for being here. All those intent to testify, please raise your right hand. Do you swear or affirm the testimony you'll give will be the truth and the whole truth?
Yes,
I do.
I do.
Thank you. You may lower your hands. And I believe the petitioner is you, Mr. Wasaki?
I believe that's correct, Your Honor.
Okay.
Well, mom's petitioner, Your Honor, but we have no objection to Mr. Wasaki going first.
Oh, my apologies. I have it down wrong. Okay,
No,
so,
that's okay.
all right. Are you all giving an opening statement or are you waiving opening?
Just briefly, Your Honor.
Okay. All right. You may proceed.
Your Honor, with regard to the matter before the court, there was an associate judge's rec from May of 2022 that was de novoed by both parties. With regard to father's de novo is a singular issue. We're asking the court to overrule the associate judge's rulings requiring Mr. Tharp submit to PEP testing and eliminate those requirements. With regard to that request, the evidence today will show the court a number of things. First and foremost, when the evidence is presented, I suspect the court will be somewhat surprised. The court will see that as far back as 2021, there was an agreed order entered where Mr. Tharp, the court would see that he extended a massive olive branch. He was in a situation where Miss Collins had been held in contempt. She had violated court orders. She was not seeing the children. She was making countless poor choices. And he set aside all of those differences and entered an agreed order with her, keeping her from going to jail, continuing her relationship with these children, supporting her relationship with these children, and allowing that to move forward. The court will see that there was a reunification therapist ordered, but that the evidence will show that the reunification, again, because mom, not because of dad, not because of the court, by mom's election, mom had elected to stop seeing her own children. But the court will see that she didn't comply with the reunification. The court will see testimony from the May 20th hearing before the court, where mom, although offered, made everyone clear, I'm not going to even call my kids anymore. I'm not going to call them on the Sundays anymore. I don't need them. When Mark Tharp, the court will see the exhibits where the father offered her more time and she said, no, thanks. I don't want to. The court will see communications from her with regard to parenting facilitation, not responding to the parenting facilitator, canceling appointments, canceling sessions, saying that she doesn't think that it's necessary. The court will see that the AJ rec entered by the court continued supervised possession for mom and kept her husband, who's sitting with her, enjoined from being around the kids. Why? The evidence will show that the testimony of the neutral experts in this case was that the children, in particular the oldest child, reported that mom had assaulted her, had hit her in the head with a cell phone, had held her down while stepdad assaulted her. All of this, the court will see from the testimony of the experts. The experts said that the child's statements were credible and consistent. The court will see that although all of this evidence was overwhelming, that Mr. Tharp continued to do his very best to facilitate the relationship between the children and mom, asking, when are we getting back to reunification? Why can't we schedule appointments with the parenting facilitator, et cetera, et cetera. The court will also see communications from mom where mom says, Mark, you've proved alcohol consumption is not an issue. I'm no longer concerned about your alcohol use. Period. End of story. Mark, you passed the PET test. I'm not concerned about your alcohol use. And additional communications. But once mom gets herself into a pickle, what is the first thing mom does? Oh, court, dad's an alcoholic. The evidence will show that the amicus has testified in this case that the children have a significant rapport with her and they've never reported an issue with dad. They've never reported an issue with dad and alcohol. They've never reported a concern with dad and alcohol. The evidence will show that issues with mom, however, continue, and that this alcohol thing is her only shtick, the only one. It's every time I try to settle this case, it's the one thing that they try to hang out there. Oh, well, XYZ. Your Honor, we need it removed to be able to get this case resolved and remove their last, like I said, their last impediment to getting this thing across the finish line. But the problem that the court will also see is that issues continue with regard to mom. As of recent, one of the children obtained several knives from mom's house. Mom was aware that the child obtained these knives and box cutters and didn't tell anyone. Didn't tell dad, didn't tell stepmom, didn't tell the amicus. And that the child began cutting herself. The court will see testimony of Jennifer Leister that the child reported, yes, the blood on the box cutter was because I started cutting myself deeper and deeper. And so these are some issues, Judge. We believe that based on the evidence before the court, that the PET testing requirement of Mr. Tharp should be removed to allow us to focus on the actual issues. With regard to the child cutting, mom does not have access to that child at this time by court order of Judge Lee. There is a reunification therapist in place. And Your Honor, we need to focus on the important issues. Mom's relationship with these kids' mental health. What we don't need to be doing is throwing rocks at the one stable rock that these kids have, their dad. We need to let him continue to be the good dad that he is, continue to be the supportive co-parent that he has shown to be, the gracious co-parent who could have literally buried the other parent if he wanted to. We still have an order, Judge, where we could revoke revoke her suspended commitment, and we haven't filed to do it. We haven't set hearings to revoke it, to put her in jail, because he doesn't want to. He wants her to focus on her relationship with her kids and focus on being a good parent instead of focusing on him. That's what the evidence will show. Thank you, Your Honor.
Thank you. Attorney Bowman?
Yes, Your Honor, briefly, thank you. Your Honor, I do, this is a very difficult case, I will say that. The two primary issues are the fact that mom needs a healthy, well, actually the children need a healthy relationship with their mother. The children need to have a good environment for their mental health. And as part and parcel of both of those two necessities, protecting the safety and welfare of the children, protecting the children's best interest, Mr. Tharp has to undergo alcohol testing, at minimum, alcohol testing. As I mentioned earlier, Your Honor, we are the petitioner in this case. This case was originally filed because all of the experts, the evidence will show literally all of the experts, including mom, had a concern about dad's alcohol consumption. I'm not talking about at night. I'm not talking about when he doesn't have the children. I am talking about showing up to children's therapy sessions drunk. I'm talking about showing up to parent facilitation sessions under the influence of alcohol. And I'm talking about even going so far as to recently, prior to current counsel's involvement, showing up at my law firm drunk, eating, literally eating, chewing tobacco in the middle of a deposition. That is what the evidence will show. So mom filed this lawsuit because of dad's alcohol problems. Dad told mom and the parent facilitator, I will take the test. In fact, I'm going to take the test. And then the evidence will show he submitted in writing, I took the test. Did he take the test? Absolutely not. Why? Because he wasn't sober and he knew the test would be positive. He waited until he received a positive test result. Now, the email that Mr. Wysocki referenced, you will hear my client talk about that email. After that email, Judge Beecham ordered through a temporary restraining order that Mr. Tharp undergo testing. Did he do that? No. He has not followed to this day the testing requirements. What he will do instead is he will go off and he will take a urine analysis test, which goes back 3 days. Mr. Wysocki, can you please mute yourself? Thank you. He will go off and he will take a urinalysis test, which goes back 3 days rather than the PEth test that was ordered, which goes back 2 weeks. And he will kind of do it at intervals where he knows those test results are going to be negative. And then he'll submit that result as like, look, here I am. I'm a sober dad. I'm fine. That's not the case. If he were a sober dad, he would follow the testing schedules that have already been ordered. He is in violation of the order. The orders that were referenced about my client not following and a previous contempt hearing, those were all concerning our family wizard responses, timely responses to our family wizard. Those were not concerning substantive safety and welfare, best interest of the children issues. That's what the evidence will show, even though those really aren't even relevant for today. The relevant issues for today are the fact that 100% yes, Mr. Tharp should undergo alcohol testing. 2, I absolutely agree that these children, in order to have an emotionally developmental mental health, healthy mental health perspective, need a relationship with their mom. And they have not been able to have that because of actions of Mr. Tharp. I've made this analogy in this case before to the fact that Mr. Tharp's parenting style and his wife's parenting style, the evidence will show, is a lot like the way that my grandmother talks negatively about someone. She doesn't say mean things about someone from church, her church group or whatever, but as soon as she says the words, bless her heart, I know that she's actually throwing a little shade at that person's direction. And in this case, and in this family, Mr. Tharp has a way of making his children view their mother in a negative light. And he doesn't do it obviously. He does it subtly, but in a way that those children 100% understand that he doesn't like their mother, that his wife doesn't like their mother, and that he does not support those children having a healthy relationship with her, which is why it is so important that the reunification therapists continue. No one disputes that. We all agree with that. But at the end of the day, this mother needs time with her children, and this father get help for his substance abuse issues. And until he does that, and until he admits that he has a problem, he is going to continue creating an environment that has resulted in the oldest child actually cutting herself. She's not suicidal, but she's on the verge. And it's not my client's fault because my client hasn't had any access to her. It's the environment that she is in at her dad's house.
Mhm.
The phone incident that was raised in opening statement, you will see evidence that that has been totally dismissed. The only person that made a police report about that incident was Mr. Tharp himself, which was investigated and was ruled out and completely dismissed. No charges were filed. The only police report that has ever been filed regarding this family concerning these children was made via a 911 call from Lauren, the child who's currently potentially suicidal, calling from her closet 911 because her father and her stepmother are screaming about her mother so violently that it is terrifying. That's the only person, only independent person other than this father that's ever filed a police report. And so don't let him fool you. I know you won't, and that this court will hear the evidence, but the cloud of chaos that's being created by dad is all as a result of his anger towards his ex-wife, my client, and his sister, which is in significant need of treatment. Thank you.
Thank you. All right, Mr. Wasaki, you may call your first witness.
I call Mark Tharp, Your Honor.
Okay.
Mr. Tharp, will you please state your name?
Mark Earl Tharp II.
And Mark, you're familiar with the term called evidence, right?
Yes, sir.
Yeah. We've been at this a little while, right?
Yes, sir.
Okay, you heard that the quote unquote, the issue was Mark Tharp. Did you hear that a minute ago?
Yes, sir.
Is Mark Tharp enjoined from access to any of his children?
No, sir.
Is there transcripts riddled with Mark Tharp abandoning his children?
No, sir, not to my knowledge.
Are there therapists and otherwise in session to restore your relationship with your daughters?
No, sir.
Okay. Yeah. You've heard the term a reality check.
Yes,
You've heard
sir.
that? Okay. Do you think that this case needs a good reality check?
Yes, sir.
Okay. Do you think other judges have tried to give this case a good reality check?
Yes, sir.
Okay. Do you think that if these attempts to attack you, black cloud you, are removed from this case, that might help give the other side a good reality check?
I could elaborate on that, but the answer is yes, sir.
Okay. With regard to this case, I'm going to show you what's been marked as Father's Exhibit 0. Are you asking this court to overrule the associate judge's ruling requiring you to PET test?
Yes, sir.
Your Honor, I offer Father 0.
Any objection?
No objection.
Father's exhibit.
No objection.
Father's exhibit 0 is admitted.
With regard to this matter, contrary to what was represented, were there prior orders in this case that you agreed to back in January of 2021?
Yes, sir. That was our most recent out of court settlement modification.
Okay. Your Honor, I'd offer Fathers 1 as the agreed order in suit to modify parent-child relationship.
Any objection?
No objection.
No objection.
Father's exhibit 1 is admitted.
With regard to Fathers 1, in that agreed order, were there issues at that time with regard to Miss Collins and the children?
Yes, sir.
Had Miss Collins been held in contempt?
Yes, sir.
And did you push her all the way to trial and try and get all of her visitation denied?
No, sir, did not.
In fact, instead, even with all the issues, had there been visitation issues
Meaning,
with regard to her not seeing the kids?
so we're talking about the prior to entering in the agreed order,
Yes.
there had been, yes, lapses.
Okay. How significant a lapses?
Just like kind of for lack of engagement with the girls, even just over the phone sometimes.
Significant periods of time of not seeing them?
Yes, and yes,
Significant periods of time of not talking to them?
for a period of time, yes.
Okay. With regard to that, was there also a reunification order entered requiring reunification therapy entered at the same time, January 5th, 2021?
Yes,
Your Honor, I'd offer Fathers 2 as the reunification order.
Any objection?
No objection.
I didn't hear no, Attorney Hill, I didn't hear your answer clear.
No objection, Your Honor.
Okay, Father's Exhibit 2 is admitted.
And even, well, do either of those orders, are you restricted in those orders? Is your possession restricted?
no, sir,
Is there something in those orders saying that you have an alcohol problem?
no, sir.
Even though these orders were in place, did issues with mom's relationship with the children continue?
Yes,
Did we have a hearing on May 20th of 2022?
yes, sir.
As part of that hearing, were there allegations like we heard today that you had somehow interfered with mom's possession?
Yeah, I recall that, yes.
I'm going to show you what's been marked as Fathers 3A. Your Honor, I'd offer Fathers 3A as certified portions of the May 20th, 2022 hearing transcript.
Any objection?
For optional completeness purposes, Your Honor, we would submit the entire transcript.
Okay,
If they do that, Your Honor, we'd have no objection to them doing that.
okay.
And I would offer 3A.
Ms. Hill,
No objection, Your Honor.
thank you. Father's Exhibit 3A is admitted.
And Mr. Tharp, if the court looks at Exhibit 3A, part of Exhibit 3A is the testimony of Jennifer Leister, and Miss Leister is your daughter's therapist?
But yes, for both of them, but she sees Lauren on a weekly basis, Lizzie as needed. Elizabeth,
Okay. And even if we start at the front, does Miss Leister testify about mom's history of self-alienating?
yes, sir.
And does she testify about the physical assault on the child by mom?
Yes, sir.
Okay. Also, if we look, I attached relevant exhibits for the court from that hearing. For instance, the Our Family Wizard communications where mom says she's no longer going to call the kids. Do you remember that one?
I recall that. I recall that, yes.
Okay. And your exhibit, Our Family Wizard, where you're offering mom more time, but she never responded.
That's happened in the past, yes.
Okay. And but Mark, I thought that they said that you were an impediment to mom. You didn't You didn't support mom's relationship, but I see you here offering more phone calls, asking when she's going to start calling, offering more visitation. Right?
Yeah, in my settlement to, that I provided in October of 2022, actually gave more time than what we agreed to, in that last, whatever, exhibit.
Okay. And then we also showed mom's exhibits, where she communicated to you and father's 30, father's 31, where she's saying that you've beyond proven alcohol is not an issue. Right?
Yes, sir.
And in 31, she acknowledges your past PEth tests. Do you see that?
Yes, sir.
Okay, but I thought opposing counsel said you weren't taking PEth test, but this says her own client is saying that you've passed PEth test, right?
Yes, sir.
Okay, well, that's not what I heard. Okay, well, let's look at exhibit 3B. Let's look at exhibit 3B, because remember what we said a minute ago when I first called you as a witness, I said we were going to talk about evidence, right?
Objection leading.
Sustain, don't lead, Mr. Wasaki. And Mr. Wasaki, you have 3 minutes left.
Mr. Tharp, let's look at exhibit 3B. Your Honor, I'd offer 3B as a certified transcript from the May 20th hearing.
Any objection?
No objection.
No objection, Your Honor.
Father's petition 3B is admitted.
With regard to the issues before the court, in these transcripts, will the court also see the multiple past alcohol tests admitted in evidence to the court for you?
Yes, sir.
Again, contrary to the representation, will the court also see the testimony of Ms. Hill, the amicus, saying that none of the children have reported issues related to you?
Yes, sir.
Mr. Tharp, with regard to you, do you have somewhat of a country effect in your speech?
Yes, at times, I guess.
Okay, and do you dip?
Bad habit.
Oh, I saw that. What is that, Levi Garrett?
Yes.
Okay, have you ever heard of a Copenhagen buzz?
Yes, sir.
Okay, does a Copenhagen buzz mean you're drunk?
No, sir.
Okay.
Not a good habit, but it doesn't mean I'm drinking.
Okay. With regard to the issues before the court, I'm going to offer Exhibit 10A, which is the transcript of the January 9th, 2023 hearing, Your Honor.
Any objection?
No objection.
No objection.
Okay, Father's Exhibit 10A is admitted. You have 56 seconds.
And with regard to this transcript, Mr. Tharp, will the court see in this transcript additionally that, for instance, that the children report that they're happy with you?
Yes, sir.
That they have, and I see here, no issues with you.
Well, they're adolescent females, so it's not without friction, but yes, we have a wonderful home life.
Will the court also continue to see communications where you're promoting reunification therapists, reunification therapy?
Yes, sir. I have not moved off that.
And communications where you're saying, let's get this reunification process going. Why haven't you been following the order?
Yes, sir. I think it's especially Lauren's best interest that she's a totally different kid than Elizabeth, and it's just
then
a different path.
all of the communications regarding the knife incident and the mom withholding all of that information from you.
Yes, sir. That was
Okay, Mr. Wasaki, you're out of time.
I just had one last question, Your Honor.
Just one.
Based on the evidence presented to the court, Mr. Tharp, is it your testimony that it's in the best interest of the children that this testing requirement be removed?
yes, sir.
I pass the witness.
Thank you. The court is going to go off the record briefly. We have someone that just stepped into the courtroom and I'll be right back.
Okay, thank you, Your Honor.
You're welcome. Okay, we're back. Okay, thank you all for being patient.
Absolutely.
Okay, and we are back on the record. I believe Attorney Bowman, we were getting ready to start with your cross-examination.
Yes, Your Honor, thank you. Mr. Tharp, do you understand the current testing requirements for alcohol?
The ones that Judge Beecham put in place?
Yeah.
I do.
When is the last time that you took a PEth test?
Last Wednesday,
Have you obtained the results of that test?
I have.
When is the when you received the notifications from mom per the court order, why didn't you go and take the test at that time?
Objection, Your Honor. Form of the question assumes facts not in evidence.
Attorney Bowman, would you like to rephrase?
I can rephrase, Your Honor. Thank you. Mr. Tharp, you understand that mom has requested that you undergo testing per the terms of Judge Beecham's order on several occasions. Do you understand that?
Objection calls for a legal conclusion per the terms of his order. It's asking him to draw a legal conclusion as to whether or not she actually complied with the order.
Sustain.
Mr. Tharp, when you received a request from Ms. Collins to go and test, you have not done that over the last 12 months, have you?
I have not. I immediately filed the de novo.
Objection, non-responsive after I have not.
I have not.
And Mr. Tharp, you have told Ms. Collins, the mother of your children, that you have, and I understand that we have a new district judge over this court, but previously you have told her that Kim Cooks was your judge.
Objection. I'm going to
That you bought
object,
her.
Your Honor. Objection, relevance. Objection.
Sustain,
Well,
irrelevant.
Well, if I might, Your Honor, I accept the court's ruling, of course, but the reason that I'm going down this line of questioning is because one of the requests that we have on file for the de novo is the attorney's fees issue. And this is going towards his threats and ability to pay for attorney's fees.
Okay, you may ask your next question.
Thank you, Your Honor. Mr. Tharp, have you told my client that you can pay for whatever you need to pay for to obtain the results that you want in this court?
I don't recall having said that.
Hold on 1 second. 1 second.
Lack of a relevant objection, lack of a relevant time frame, Your Honor.
Sustain.
Since entry of the final order, haven't you told my client that it's not about what you can prove, but it's about what you can allege in this lawsuit?
I don't believe I used those words. No.
Have you started the alcohol evaluation that was ordered with Kevin Gilliland?
I had my intake scheduled, and then after I was about 3 months out, and then he called and said that he couldn't. He just got too busy, and that there were things going on in his personal life where he couldn't do the evaluation. But I was already was scheduled.
Objection, non-responsive.
Sustain.
Mr. Cox, oh, sorry.
Very briefly, let me pause your time, Attorney Bowman.
Yes,
Ms. Tharp and Ms. Collins, when a question is asked and it's closed-ended, it's yes or no. It'll make it go a lot smoother if you just answer the question that's being asked.
So,
Thank you. You may
Thank you.
proceed.
Yes, Your Honor. Mr. Tharp, you have not undergone the substance abuse evaluation that was previously ordered with Kevin Gilliland, have you?
no.
Pass the witness.
Okay, and Osaki, you're out of time.
Your Honor, just for clarification for the court's purposes, can I ask him one question about Dr. Gilliland?
One question.
Mr. Tharp, did you do everything within your power to comply with the order related to Dr. Gilliland?
Yes, sir.
Okay, that's it from this witness. All right, Attorney Bowman.
Yes, Your Honor. I would offer mom's exhibit. We'll just call this exhibit 1, which will be the business affidavit on file concerning the drug testing of or alcohol testing of Mr. Tharp.
Any objection?
We just don't have any exhibits. We've not received any exhibits from them in the last week, Your Honors. So
This has been on file since May of 2022, Your Honor, and it was also a previous exhibit.
Attorney Wasaki, have you had an opportunity to review these exhibits?
I think these may be some old ones from a prior hearing, and if that's the case, Your Honor, and if it's under business records, I won't object.
Okay,
I don't know if I have it under BRA.
all right. Any objection, Attorney Hill?
No objection, Your Honor.
Okay. And this is Respondent's Exhibit 1.
Yes, Petitioner. Yes, Your Honor.
Thank you. Petitioner's Exhibit 1 is admitted.
Thank you, Your Honor. And we'll call Miss Candace Collins.
Okay.
Ms. Collins, do you believe, or what are you asking the court to do with regard to the alcohol testing?
I'm asking for testing to happen. It's been requested by the court multiple times. He hasn't complied to Judge Beecham's orders, and that to me shows it's necessary.
Well, let's just look at this Exhibit 1. What was the actual value of the ethanol in Mr. Tharp's system as of the time of this test in April of 2022?
665.
And what is the screen cutoff over here under the screen cutoff section?
20.
When Mr. Tharp took this test, was this after you filed an emergency motion for alcohol testing?
Yes.
Have you had ongoing concerns about Mr. Tharp's alcohol consumption?
Yes.
Have you received, do you have the ability to pay for your attorney's fees in this case?
No.
Do you have ongoing safety and welfare concerns about your children?
Yes.
Can you tell the court a little bit about what those safety and welfare concerns are?
I'm concerned that alcohol is what started this, the claims that came from the girls. And we've had ongoing hearings that he's trying to distract from the alcohol. He's not doing the testing when requested by Shannon Lynch, our parenting facilitator, for a random test. I went that day and did a 10-panel nail drug test and the PET test as requested. He did not. And he was in primary care of our children after filing a TRO saying that I was asking them to lie about his alcohol use.
What threats, if any, has Mr. Tharp made to you about his ability to outspend you in this litigation?
There have been multiple. The first one that comes to mind is I can make reunification last as long as I want. A recording that we have on file is it just takes money. Any judge can be bought. Those are the few top of mind. There are so many on recording.
Are you asking that this court order Mr. Tharp to pay your reasonable and necessary attorney's fees in this modification proceeding?
Yes.
Is there additional legal work needed to be done to get this case to final trial?
Yes, I believe a toxologist is necessary. The 665 after Judge Beecham ordered that was taken 6 days after it was ordered. So I'm not a toxicologist. I don't know what it would have been if he would have gone that day. It could have been in the thousands. So I think there are necessary experts.
And when you say if he could have gone that day, tell the court what happened. Did Mr. Tharp attempt to avoid taking that test that he was ordered to take?
Yes.
How did he try to avoid it?
By having his own testing a urinalysis done at his home.
And that was one time, but the time that we're talking about right now, was there something that he did to try to avoid taking the test ordered per the TRO?
I'm sorry. I'm trying to think of this day.
Did Mr. Tharp fake having COVID in order to avoid
Oh,
the test?
yes. I'm sorry. There have been so many times we've asked him to take a test, and I can't recall. Yes, he faked having COVID. He had a doctor write on a prescription slip, a doctor that was a friend of his, that he had COVID, but there was no actual test results, and that delayed his testing.
Have you attempted to get to obtain a job where you're receiving more pay so that you can afford all of your bills in this litigation?
Yes.
Is your new job, is that income sufficient to cover all of your litigation expenses?
Unfortunately, no.
Are you asking this court, what are you asking this court to do with regard to your husband and his ability to be present when your children are in your possession?
The claims that have been made are keeping my husband from having a relationship with our children, and we need him to be present. It also, causes times where we aren't able to see each other. He has to be away during those possession times.
And when the court ordered that Byron was not to be present during the possession periods, was that prior to the charges being dismissed against your husband?
Yes.
And the charges that we're talking about, was that the police report filed by Mr. Tharp?
Yes, and that was filed a month after the incident even happened.
Okay. So there are no ongoing charges against your husband?
No.
And there were actually never even any charges filed?
No.
Your Honor, as an officer of the court, I'm going to have to interject. I don't think it was intentional. I think I understand what opposing counsel was trying to say there.
Objection
But
to
that was,
well,
well,
objection,
no,
no,
that's what.
One at a time. My court reporter can't do both of them.
As an officer of the court, I have to bring it to your attention when a false representation is made. The injunction in place by
no legal objection.
Attorney Bowman, let him finish. I'll give you the opportunity.
the injunction in place by Judge Lee, which was not de novoed, was put in place after these alleged charges were dismissed. So that representation that was just made, I understand they were referring to Beecham, but with regard to Judge Lee's injunction, that would be a false representation, which I have to correct with the court as an officer of the court. So.
Thank you for that, Attorney Wysocki. Attorney Bowman?
Yes, Your Honor, move to strike sidebar and speaking objection.
Sustain.
Thank you, Your Honor. Offer the full hearing transcript from the May 20th, 2022 hearing as Mother's Exhibit 2.
Any objection?
No objection.
No objection.
And Your Honor, I'll pass the witness and I will call from that hearing transcript. I will would like to read Leister's testimony at page 45, lines 1 through 3.
Okay, one second before you begin. The court admits Mother's Exhibit 2.
Oh, thank you, Your Honor.
You have 1 minute and 38 seconds left.
Oh gosh, okay. Well, then I will not read from that transcript, Your Honor. And I will call myself as the next witness, Your Honor. My name is Lacey Bowman, and I am the lead attorney for Candace Collins, and I have been consistently during this modification proceeding. I would ask the court to take judicial notice of the file, including the multiple emergency motions for alcohol testing that were filed, all of which were granted concerning Mr. Tharp's alcohol consumption. You will see in Mothers 2 that all 3 professionals testified that they had significant concerns about Mr. Tharp's alcohol consumption, including slurring his words and being in the presence of the children. You will see in Mothers 2 that Dr. Albritton also testified that he was concerned, and this is specifically, if you look at page 179, lines 16 through 180, lines 19, as well as page 180, lines 20 through page 181, you will see where he talks about how Mr. Tharp's statements in front of these children are creating a situation where they have an estranged relationship with their mother. Dr. Albritton said he has no concerns with mom's possession time. He was the reunification therapist. Mr. Tharp motioned the court to remove him after Dr. Albritton brought up the alcohol concerns. Mr. Tharp did the same thing with Shannon Lynch, the parenting facilitator, when she brought up issues with Mr. Tharp's alcohol consumption. And so you will see a pattern in the court's file of Mr. Tharp creating legal chaos anytime anyone points to his problem. He's asking the court to remove the alcohol testing requirement, even though he hasn't even complied with the current orders that are in place concerning testing, as well as the alcohol evaluation he is to undergo. So we're asking the court to leave that in place. I am asking the court, I have continued work that needs to be done, including discovery, preparing for trial, motion practices. We have a report back hearing with Judge Lee at some point concerning the reunification therapy. And so there is reasonable and necessary legal work that needs to be accomplished. And my client does have an outstanding bill with our firm, somewhere around $40,000, Your Honor. And that is part of her requested relief today, is asking Mr. Tharp to pay her reasonable and necessary interim attorney's fees, which he has the ability to pay per the statements that he's made and per my client's testimony. Thank you.
Thank you. You ran out of time. I gave you a few more seconds because I did allow Mr. Wysocki to ask additional questions. So I do have a couple of follow-up questions. Attorney Bowman, could you give me the dates that mom actually requested for dad to receive PET testing and he did not do it?
Yes, Your Honor, I certainly can. It might take me a quick moment only because I will pull up those emails. Hold on, Your Honor.
Okay. And we're off the record.
Yes, Your Honor. I'm going to put it on a brief mute so I can ask my paralegal to help me for a moment, if that's okay.
Yes, that's fine.
Ms. Bowman,
Her exhibits. Oh, I don't. And Attorney Bowman, could you also send the exhibits to the court reporter?
Absolutely, Your Honor. Yes.
Thank you. Attorney Bowman, while you're doing that, we're going to go back on the record.
Yes, Your Honor.
Okay, we're back on the record. Attorney Hill, did you want to
Yes, ma'am.
call your first witness?
Your Honor, I don't really need a witness per se. I would like to make a recommendation, or at least allow the court to see it from where I'm coming from.
Yes, please.
Here's the bottom line. This case has been going on forever. The girls are very open with me and actively talk with me. So with that being said, it appears that every time we're in court, it's more about the fighting between mom and dad and mom versus really focusing on what the bottom line issue is. And these are two young girls that have two parents that cannot get along. There have been, alcohol issues brought up and possible drug issues brought up on mom's side and back and forth. And I think these parties, and when I say this, spend so much time recording quote calls that it's actually going to end up at some point backfiring, especially on mom, because the kids are now recording their conversations. And I've heard stuff that have been a little bit as far as concerning to me. In the last year, the oldest child, yes, she's a teenager, she's going boy crazy, but she's emotionally in a very vulnerable position. I do worry that if we continue moving on with this, she is going to do something to herself. And I've been working with her therapist to make sure that she's doing well. She has actively said, I cannot have contact with my mom right now. I am not in a good position. She doesn't understand me. She doesn't get me. Until we can start this reunification therapy, I don't see things changing. I mean, just alone, it took us, I think, 2.5 months just to get the order signed from both sides, just to get the children started on this reunification therapist. It just seems like we're pointing so many pictures at this test wasn't taken or this test wasn't taken, that nothing has been done regarding the girls right now and how to fix that relationship. They do need their mom, but at the rate we're fighting right now, both sides seem to be missing the picture. One, testing, drugs here and there. It's not about that. It's about the kids right now. As far as the alcohol with Mr. Tharp, the girls honestly have never voiced any concerns. And so I would like the court to be aware of that. They have voiced concerns regarding some THC and some vaping that has occurred on mom's end. I recently found out that, and we were here at a hearing last month where a vape pen was found in mom's purse. Lauren, Izzy actually pulled it out, gave it to Lauren. Lauren took it home. And she was going to show it to her stepmom and then ended up getting in trouble with the school for leaving it there. But the bottom line is I have concerns all the way around. The relationship between the children and dad are fine. They love their stepmother. I have no concerns with Mr. Collins being around the girls, except right now Lauren does not want to have any contact with mom. Izzy, the little one, is happy-go-lucky. No issues, but I honestly don't have concerns with either one of the party spouses. It's more of how they can figure out how to get along so we can help these girls. It's going to get worse before it gets better if we don't nip it in the bud.
Thank you, Attorney Hill, for your recommendation.
And Your Honor, I did find those emails. There was an email, the most recent one was January 9th of 2023. And I can share that. I had asked that Mr. Tharp undergo the PEth test with national drug screening tomorrow, and confirmed with national drug screening that he did not appear for the PEth test. And that the Judge Beecham's order required him to go within 24 hours. So there was that one. There was also another request.
January the 9th?
Oh, I'm sorry, January the 9th. Yes, Your Honor.
Okay, is that the test that I'm looking at? It says he went on the 9th.
That was January 9th of 2023. I think the test you're looking at was from 2022.
Oh, no, this one is January 9th of 2023. It's on file with the court. It's been on file since January 23rd of 2023.
Okay, I have not seen that test result. Was that a PEth test?
Yes.
Okay.
That Judge Lee ordered.
Oh, that was a different one. Yes. So that was the one that Judge Lee ordered. Yes. Okay. Yes. Okay. So there was that test result. So maybe he did go, but just not per the timing. Okay. And then there was one October 4 of 2022 requested, and I have that email if Your Honor would like for me to pull it up.
Oh, no, thank you.
Okay. And then I also have one October 4, 2022. Those were the three that and June 20th of 2022. I don't know if I said that one.
Okay, I have June 20th, 2022, October 4th, 2022, January 9th of 2023, correct?
Yes, Your Honor. And there may be more. I have my office looking, but those are the three that I could find doing a quick search of my email.
Okay, thank you. And Attorney Wasaki, have the children begun reunification therapy?
Yes.
Okay.
Yes. Yeah, we as Ms. Hill pointed out, we had a lot of, I don't know why, because it benefited their client, a lot of roadblocks to get the order entered, which ultimately the order that I had tried to get entered 3 months earlier got entered 3 months later by the court.
No, we
And
were
so-
reading the language, and that was not, I disagree with the
So
plan.
the court can see it in the record. My order got entered. So
There's no dispute on, I just wanted to know, had they started it?
yes,
Yes, okay. How many
And-
sessions have they had since starting?
that's a good question. Oh, Mark says one.
Just Lauren,
Okay.
and my intake was without the girls.
Okay. And Mr. Wasaki, if you don't mind me speaking directly to your client, asking this.
Sure.
Okay. When is her next session?
We haven't set it yet. There's a parallel process where the professionals have decided that Lauren needs to go through a DBT process. We've already had several conversations with the DBT therapist, Dr. Cooper, DBT Associates of Dallas, and they're trying to put her on a schedule. Jennifer Leister is the one. And so there's some sort of Ellen Hutton, who's the PF, I'm not sorry, who is the new reunification therapist, and kind of has a different view of how does DBT need to happen first, just sort of the order of operation, or can they be in parallel? I'm in no way trying to prevent reunification from occurring. I'm fully supportive.
Okay. Okay. All right. I believe you all answered all of my questions. Let's see.
And Your Honor, there's only a couple things I would point out to the court as the court looks through the evidence. The court will see a number of alcohol tests that Mr. Tharp has passed throughout the evidence of both transcripts that I admitted. The court will also note that in the file, there was no injunction against Mr. Tharp consuming alcohol, period. That didn't happen until Judge Beecham in late last year, injunction against consuming alcohol when he had the kids in his possession. But before that, there were no injunctions. And so then what the court will see is that on some.
Hold on, Mr. Wysocki. I do appreciate you giving me some background because obviously this is new to me.
Yeah.
What I'm going to do is take a look at both of both of you all with the evidence that you submitted. And the court is going to give a ruling and definitely taking into consideration what Attorney Hill has provided here today. So my goal is to get you a ruling, if not by the end of the day, by tomorrow, no later than tomorrow, because I don't want to further delay this case. And I just would like to say to Mr. Tharp and Mrs. Collins, both of your attorneys did an amazing job. I just want both of you to know that. And I wanted to make sure that I said it to you both directly. So that concludes our hearing. Thank you all for being here. And thank you again for your patience.
Thank you, Judge.
Thank you for the court's time. We appreciate you, Your Honor.